If you pardon the mention, my lord, Section 14 of the Surface Act, this order has been passed. Yes. Section 14 of the Surface Act order has been passed. Now, when the police personnel came to my house in 2 day 9 a.m. They directed to vacate premises on before the 11th, 11 of go before the tribunal case is pending. I have also filed an interim application. But due to the learned presiding officer is not there, matter could not be possible to take over. File your memo. So, please, otherwise, today they can vacate minutes because they have already directed to vacate the premises of Pali.
Pardon me, Lordship, I want to mention last time also.
Second copy by oversight will not file. We have filed it in the registry. So let the second copy be called for. My friend is here, class is here for that national highway. So we have already stopped in a copy. Mr. Das. So there was an interim.
Mr. Das.
Monday, convenient to.
I have sought for instruction. I have not received because yesterday was holiday. Yesterday I sought them. So what do you want?
Whenever you call for that second copy.
No, we are now. There is no problem. We can get it here. So, copy of the writ petition is available in the second. There is no problem now because if the paperless things, we can see it. No problem. So, if you want it next week, it can be registered next week. Any interim order is there?
There is an interim order. They have already demolished. Now my house is open, wide open.
No. If interim order is there, so let it come after the puja holidays. What is that?
No, I want it.
Oh, it is already. Then let it come next. All right, Mr. Padit, Land Council, for the petition submit that he has already served the copy of the writ petition on Mr. Amitabh Das, Land Council, who is appearing for NHI. And Mr. Das submits that he has already sought for instruction in the matter, and the matter will be taken up next week. Put up this matter on Tuesday to come.
Great.
Pardon your Lordship.
Tuesday, 8th of October 2020. Yes.
Pardon, Lordship. Your Lordship, it is that Group D employee court peon matter, Lordship. On Monday, Miss London Senior Counsel Miss Rath has mentioned, your Lordship. They are not getting their
Tuesday, not Monday. Monday there is a different bench here.
Next Tuesday,
yes.
Pardon me, Lordship. The petitioner is seriously ill, which underwent kidney patient, Lordship. And the prayer is for compassionate appointment and kindly allow to.
My other application is pending before the district judgment. Fresh matter.
My lord, Pusana 10 years custody, interim order thila.
Supplemental list, item number 1.
On behalf of the non advocate, Miss Kiran Rao, may be taken up 2 weeks after.
Is the Land Council in this case?
Kiran Rao.
Has he gone through the writ petition he has filed?
I am not filed instruction.
No, that is all right. If he is there, kindly tell him what does he want through this writ petition. Whether the prayer is specific, whether the amendments are there, nothing.
If you highlight in the media for that you have filed, then it's all right. We know how to do all these things. Yes. The London Council for the petition of 6 for an adjournment for 2 weeks put up this matter after eventual puja holiday. Yes.
Item 2.
Bless. May please also. Challenging the inaction of the opposite party number 2 in not considering the RR policy, not granting RR policy benefit to the petitioner. My representation on Annex 4 is pending before the opposite party number 2, my lord.
Sure.
Public.
Item number 4.
In item 4,
Item number 4, madam. It is not related to NHAI, madam. It has been executed by state government. Annex 10, page 74.
74.
Yes, the Deputy Collector Revenue has issued this to the NH authority. Handing over
Construction of NH bypass road near Jaipur town is hereby handed over to you for execution of work. The executive engineer, NH division, Jaipur. That is NH division is state government division.
All right.
Like PW, NH division is a state government. Because
C.DASH Land Council appearing for the NHI submits that the state government can
executing the work.
is to execute the work in question, and NHI has no role in it. Stop. Yes, what is your prayer?
My lord, my prayer is, without complying the provision as indicated, you will also kindly have a turn to Annexure 9. Annexure 9.
Where is your matter pending? You have got the compensation of.
But what happened here? The circular of the state government says, without giving 80% of compensation, you cannot take out the position. Now, your lordship kindly see.
All right, just we want to know that whether you have got the compensation or not.
Only 30%, my lord.
Acha.
30% that.
Where have you stated that you
I have a document. I have an next page 61.
61.
Page 61, madam. This document, your lordship kindly see.
So if you are dissatisfied with it, then the matter has to be.
But that is altogether different issue, my lord.
Yeah.
Now I am in the question. Your lordship kindly turn to their own guideline at page 72, my lord.
No, based on that, you have already received an order from this court.
But what happened?
Yes, I'm coming to 75 page.
I'm coming to that.
19/2024.
I'm coming to that.
So what happened after that?
That paragraph 18, I have stated what they have did. Paragraph 18, lordship kindly have a glance.
Paragraph 18.
Paragraph 18, my lord.
After this order.
Consciously, I have annexed that.
After this order.
My lord, after this order, I have stated they have nothing has been done.
Paragraph
Page 12, paragraph 18. Nothing has been done, my lord. Therefore,
so that is to be only seen.
Yes. Therefore, I file a contempt also.
The Canon Council for the petitioner submits that earlier petitioner approached this court in WPC number
929.
What is that order there?
Page
75, sir.
75.
This honorable court specifically
just a minute. Approached this court in WPC number 9292 of 2024 for a direction for compliance of the procedure in accordance with the provisions of law provided under
guideline
dated 1956.
Well, guideline dated 22.
Yes, it is there. Wait.
And RPCT LARR 2013 regarding determination of the appropriate compensation in favor of them.
And the last line.
The page 75.
Sir, last line.
Yes, wait, Mr. Das. In paragraph 5, it is there. Yes, wait.
The writ petition was disposed of with a direction that the grievance of the petitioner be considered, taking into account the instruction issued by the Additional Chief Secretary to Government dated 22/3/2022 under Annexure 11 as expeditiously as possible, preferably within a period of 6 weeks from the date of communication of the order. In this writ petition, in paragraph number, which paragraph? 18. It is stated that in spite of such order, even though
the same was communicated on 9/5/24.
Paragraph here.
Paragraph 18.
Has been pleased to pass the order so and so on taking into account the instruction gala.
Content file
communicate order that even though the order was communicated on 9/5/2024, but nothing has been done so far. Therefore, the petitioners have filed contempt application bearing CONTC number 6854 of 2024, which is sub judice before this court.
Now they are taking over the position.
And now the opposite party are taking all steps to dispossess the petitioner. Let the Learning Council for the who is to take instruction in this time?
NHI.
My lord, collector. Collector is appropriate.
Let the Land Council for the state obtain instruction on the amendments made in paragraph 18 and apprise this court about the development, if any, made after the order. Earlier order was passed by this court in WPC number 9292 of 2024. Put up this matter, evaded. Yes, next.
I have an IA, madam. I have an IA. And they'll cut out the entire tree, my lord. That's my status quo.
See that you will get the compensation for it.
That's me grant me status quo at least.
Sorry. Next.
But they will cut away the entire mango farm.
Item number 5.
Contrary to the guideline. That's it. That's it. Kindly consider. Till then, at least.
Okay, no stay in that. It will come after Puja holidays. Yeah.
Appearance of Piano.
Yes.
Appearance of Piano.
Who is for the petitioner?
I think item 4.
No, in item number 4, you want to be reprinted to or union of
I have solved the I have solved the
is present for the
union.
CCA is present for the union of.
My lord, my permit, instead of annexure 11, 12, 9, 10, may I correct it?
Really?
Say, paragraph 3, page 3, 9, 10 हुआ था 11, 12. That's it.
Land Council for the petitioner submits that there are some typographical errors in page number.
Page number 3. 4. I'm sorry. 4.
Page number 4 of the writ petition.
Right.
This is paperless, so you have to file a
Scan.
type copy.
Again, I will make it stand.
The Land Council may file a type copy of the said page correcting the typographical errors. Yes.
Better.
Yes, item 5. Who is? Yes.
And the petitioner moved this honorable court challenging the order of the Learned Central Administrative Tribunal, my lord. The Learned Tribunal has rejected the 2 error for regulation only on the ground of limitation, madam. Only 4 other matters already are also issued notices.
Why is
And outlined that order. The matter is posted to 7/10.
Land Council for the petitioner submits that similar matters subject is before this court in WPC number so answer. Allah, याद the order pass किसी order pass कर दो release this matter याद जो date दिया है से date जो देंगे Allah last. Yes.
Item 6.
Item number 6.
May be permitted to place it to BC.
Yes.
My lord. Here, my lord, lease was granted in 1974. After 24 years thereafter, a suo motu revision was initiated in the year 1998, and an order was passed on 11/8/1998 cancelling the lease. That I have challenged before this honorable court in WPC number 15864 of 2023, and that I have annexed at page 50, annexure 6. The order of this honorable court. Lordship may kindly point at relevant is page 52, paragraph 4 of the order. The original, may I just place, my lord?
Yes.
The original lease having been granted pursuant to the order dated 26/12/1974 passed by the Tahsildar Bhubaneswar, it was not open to the additional district magistrate Bhubaneswar to initiate the revision case in 1998 suo motu under 7A of the OGLS Act as the second proviso of the said section prescribed that after lapse of 14 years, no revision under the said section can be initiated. That apart, an opportunity of hearing had not been given. So now, my lord, there is a specific finding to that effect that it is the IDM has no jurisdiction to initiate the, apart from the fact that I was not been served with notice. Now, this is therefore remanded in this order by the honorable court. After he has decided, he has not dealt with that issue at all. That limitation issue has never been dealt in the impugned order. Now at annexure 1, order dated 22 September 2023. Beside that, my lord, whatever the reasons for which it has been cancelled, I have demonstrated at paragraph at page 10, each wise in a tabular form, that this is also not sustainable. So in other words, my lord, I have one twofold submission. A, the ADM had no jurisdiction beyond 14 years to revise a leased.
No, that has been set at naught by the Honorable Supreme Court. They have stated that Where fraud is alleged, that period is not.
In the initial order, there is no fraud. Initial order, my lord, there is absolutely no fraud has been alleged. And even in the next order, my lord, this present order, they are only saying there is certain material irregularity in not adhering to the procedure, which I have demonstrated at page 10, that is also not correct.
No, it is only after a number of cases were found to have been taken on fraud on the basis of OJC number such and such, it has been initiated. That is how the fraud has been found by the court. But
fraud is an individual situation, case on case basis.
Yes.
First order, it is not there. There is no allegation of fraud imputed in the order. So while exercising jurisdiction, in the second order, which is impugned before your lordship also, there is nothing, fraud has been written. So I agree fully with your lordship's the proposition that fraud vitiates everything. It's only material irregularity, my lord. May I just place, my lord, page 31? In the impugned order, my lord.
Come to that next page, 32. Peruse the written statement.
My lord, peruse the written statement of the petitioner's main contention of the appellant is that the lease was granted Hatomaji lessee being a poor landless person, under Khata number so. The said lease was granted following due procedure and making inquiry under the provisions by the Tahsildar, and the lessee was eligible to be granted such lease. Secondly, she has purchased the suit land from the legal heirs of the lessees and are in peaceful possession of the suit land. The cancellation are barred by the limitation with 14 years. This contention has never been dealt with. And the previous suo motu order has been quoted at the page 32 in the 4th paragraph. The suo motu begin with the suo motu revision was initiated on the basis of the observation of the Honorable Court. The suo motu revision was instituted on the basis of mistake of fact and material irregularity in the procedure. So, my lord, there is no fraud, and the fraud having a reason with me. And all other grounds which he has taken, my lord, I have demonstrated each one in the tabular form that is also not sustainable in law.
What is the status of the land now?
Land is under my occupation. I am possessing, my lord.
What you have done with that land?
I have constructed a house. And my lord, he being a scheduled tribe person, the sub-collector granted permission for before sale, alienation, under section 23. So the revenue officer has also verified while granting.
No, all these things had happened. That is how the court has found that the very initiation of leasing out the property being illegal and the subsequent all action has to be held to be illegal only. Initiation of lease, grant of lease itself was not proper.
My lord, after 24 years, without even finding out any material to that effect, besides the particular lease.
No, you say that nothing has been mentioned of that sort in 1998 order.
Yes, my lord. That's nothing has been sort of restricted. And that also I have annexed at page, annexure 7, page 53. It's only procedural. The same thing is being repeated in the next order.
No, the land was lying fallow when it was placed for transfer.
At the time of
it was not used for the purpose, it was leased out.
Well, leased out purpose has been lost after, as per section OLR Act, my lord. After 10 years, it can be A and B.
No, you can sell it out. That is not the question. But the purpose for which the lease was granted was followed or not?
Yes, my lord.
The land was lying fallow?
Lying fallow at the time of granting lease?
No, not at the granting of lease. At the time when it was transferred.
Yes.
See,
yes, my lord. Yes, my lord.
Ah.
It was flying fellow. So fellow means it's a for agricultural purpose. That what they use was continuous.
How
Fellow
can
doesn't.
it be said to be fallow? Fallow means no activity is being taken off.
My lord,
What purpose this lease was granted?
my lord, purpose is not stated in the lease.
No, what for you had asked for the lease?
No, no,
For
my lord,
residential building, for agricultural purpose, what was your purpose for lease?
that is they have to say from the record that purpose.
Point six.
The lease has been granted for agriculture.
No, he is saying that he doesn't know.
The lease has been granted for agriculture
And it
purpose,
was
but
lying
the
for
land has been not been put up for cultivation. That is there. And if it is granted for agricultural purpose, then how he has constructed a house therein
My lord, I'm just saying.
to take the status of the land. It appears that the lease has been granted for agricultural purpose, but the land has not been put up for cultivation. When a query is made to the land council for the petitioner about the status of the land, government land pertaining to plot number so and so, khata number so and so, in so and so, land council for the petitioner submits that he has constructed a house therein. Let the land council for the state obtain instruction on this aspect, put up this matter on such and such date. Yes, next.
Maybe, my lord, status quo.
Let it come, let the instruction be obtained.
All right. Obliged.
Item number 7.
Permitted to withdraw to the liberty to file fresh non-merit.
But wait, these petitions, prior to this, my lord, there are 9 cases my lord has disposed. They have not brought to my lord's notice the correct fact.
He wants to withdraw where you
Better application.
land council for the petitioner seeks permission to withdraw the application. Disposed of
Liberty to file.
Yes. Next.
Item number 8.
May I please, my lords? This is one of the better, my lords. The petitioner before your lordship is the second wife of the deceased petitioner claiming my lord's family pension under the Central Civil Service Rules 1972, my lords. Yes, what has happened? Deceased pensioner, the husband of the present petitioner, my lords, expired in 2017. Whereas his first wife, she was issueless, and during Millard's lifetime of the first wife, she has also expired in the meantime in 2016. Petitioner retired in 2008. First wife expired in 2016, and husband of
petitioner retired in 2008.
1996.
No, not petitioner.
Petitioner's husband.
Petitioner's husband.
What he was doing?
He was postmaster.
Yes.
It's a central government pensionary establishment. So he retired from, I think, the postmaster in the year 1996.
Where is the impugned order?
Impugned order is the order passed by the learned Central Administrative Tribunal. That is Annexure 13.
13.
Yes.
17/4/2023.
So on what ground it has been torn down?
Yes, because learned tribunal says, first of all, that you have not informed in form number 3 the family members which you have disclosed not incorporating the name of the second wife. Because in form 3, the deceased pensioner has mentioned the name of the first wife and the children. And the children, they are out of the marriage of the second wife and the deceased pensioner. Those names are there, but second wife's name is not there. Because that point I will address, because that is Supreme Court judgment saying that form 3 is the information, so that will not weigh with the claim of pension by the second wife. The second is, they say that second marriage being not recognized under law, section 11, your lordship knows, it's a void. Second marriage is void. So therefore, a void marriage cannot be taken into consideration for the purpose of grant of this pension benefit. And this matter is not fully addressed. Before I take in detail, the matter of this case, this matter is fully addressed by Honorable Bombay High Court. Similar question arises. Bombay High Court, with great applause to the central government for formulating the rules protecting the fundamental right of the second wife. Saying elaborately that how second wife, for no fault of his, when marriage, a man who has first wife should be protected and given personal benefits. And with great applause, he has not, all these things are there in judgment, saying that
she is entitled, second wife is entitled to pension benefits under the civil. That's a case of railway pension, say, Rule 75. And Rule 75 of the railway pension rules is parameter to Rule 54 of the present central civil pension rules, parameter provision. And here, the Bombay High Court protected and matter went to Supreme Court. Honorable Supreme Court has also.
No, you mean to say that, let us say he has married for the first time, again suppressing the first marriage, he got married for the second time. In that way, the first wife will be deprived of the getting pension, second wife will get.
Because before, because first wife, before death of the deceased pensioner, the government servant who expired in 2017, first wife was predeceased. He was already expired in 2016. So she had no claim for any pension. She has not made any claim because by the time she was alive, all through the petitioner alive, I mean deceased petitioner pensioner alive, she was there. She first wife expired in 2016, and in 2017, this husband of the present second wife, he expired. So therefore, now the second wife came up with a representation to the central government, making a claim of pension on the civil pension.
No, he retired when this man retired.
Retired in 1996.
1996.
Yes.
So,
No, first wife died on?
First wife died in 2016.
16.
And the deceased pensioner, husband of the second wife, he died in 2017.
So deceased pensioner means another wife. This is third.
Second, not third, my lord. The second.
Now, who is then deceased pensioner?
Deceased pensioner is the postmaster, my husband.
Oh, this is postmaster,
Exactly.
husband.
All
right. That means he was the pensioner.
Correct.
After the first predeceased.
Predeceased, correct. Predeceased.
And the second one was after
the death of my husband.
But her name did not come in the form.
Exactly. Because this is not reflected in Form 3, the declaration given to the government.
The name of the children have been
My children's name are there, but my name is not there. And Honorable Supreme Court says mention of
super legitimacy of the children of the second wife is all right.
Correct.
But what about this?
And Honorable Bombay High Court says that Section 11 of the Hindu Marriage Act doesn't stand in conflict, either interdict or may not see in any way impede wills. So far as the benefit, it's a voluntary, it's a scheme which is given for the benefit of the employee. So therefore, the claim made by the second wife cannot at all be impacted because of Section 11 of the Hindu Marriage Act. That is specific kind of the Honorable Bombay High Court, and this is also affirmed by the Honorable Supreme Court. And one more thing which the Central Administrative Tribunal in the order has mentioned, which is not there in the order, saying that that's Rule 21 of the Conduct Rules. Conduct Rules says that you can't have
restrictions regarding marriage.
Yes, second marriage is not possible.
Yes.
So Honorable Supreme Court said, keeping that matter open, because that was not there in the order of rejection also. It was only inculcated the mind of the Honorable Tribunal, or Tribunal in addition to the finding that
when that second marriage took place, according to
second marriage belongs during that was with they are staying together. We are the first wife, second wife, and the.
On what basis you say that she is the second wife?
No, on what basis?
Yes.
Because you will kindly see my voter identity card, which is given under representative. I have annexed the voter card now. Voter card. Page 28. And my children, those who are already my daughters have been married, my son has become major. They have given joint affidavit, also confirming that the petitioner is my mother and the postmaster who died is my father.
No, they cannot make it legitimate, sir.
Page 28, for a while, my respect, page 28. It's an election identity card given by the election commissioners.
No, the question is that something must come out from that man who has died, who was the central government employee, that yes, I have married to this lady, but during her lifetime, she has never disclosed before his authority that I have married to this lady. Now, this lady suddenly comes out in 2023 or whatever it may be and claims compensation, pension for Mr. X.
Understand. That's a great humility. One thing I will say, that it is nobody's case that he is not the second wife.
No, but at the same time, one has to be widow to get the pension.
Exactly.
How can she be taken as widow?
Nobody is disputing that, sir, but the court has to be satisfied that
Yes.
she is the second wife or
There's
whatever.
two documents I'm bringing to Lordship's notice.
Yeah.
One is where this identity card, where the election
When was it printed?
issued by the government of India.
When was it?
Election Commission of India identity card. One, a wife.
केवे এটা হইতলা? After the death of the husband or what?
This is no.
Huh?
This is issued on 15/12/2008.
हाँ.
Long back.
यांकर death केवे ହେଲା?
After death ହେଲା 2017. And wife of Bhavagrahi Naik. One. Second document, the legal heir certificate issued by Tahsildar. Page 27.
That means after your retirement, you
Yes.
After by no,
Much after.
not after the retirement.
Yes.
retirement.
After retirement only.
96 रे.
Because you
କହିଲେନି କି ରିଟାୟାରମେଣ୍ଟ ହେଲା 96 ରେ
96.
ତେଣୁ 2008 ର ଯଦି ଏଇ ଆଇଡେଣ୍ଟିଟି କାର୍ଡ ଦେଖଉଛନ୍ତି ତେଣୁ 2008 ରେ ଆମେ ଯଦି ବି ଧରିବୁ 2008 ରେ ସେ ମ୍ୟାରେଜ ଟା ହେଇଛି
ଆଜ୍ଞା।
ତାମାନେ ଏଇଟା ହେଲାନି ତାର ରିଟାୟାରମେଣ୍ଟ ର ପ୍ରାୟ 22 ବର୍ଷ ପରେ 22 ବର୍ଷ 12 ବର୍ଷ ପରେ
Let us assume he has married the second wife's marriage is after his retirement. Then also mirrors whether before or after mirrors. So far as benefit or family pension scheme is concerned, even Honorable Bombay High Court has also dealt with that it will not be impaired in any manner. Whether it is before or after the date of retirement, once it is established that subsists second marriage, mirrors.
Mr. Sahoo, just tell us that suppose this man would have died in the year 2000, let us say 2010.
2010.
While the first wife was surviving. So obviously this lady would not have got pension.
First wife will that is
For example,
under Rule 54 also provides if there are more than one widow, then also that will be shared. Pension will be shared between them. That also provision, and Honorable Bombay High Court has also taken cognizance of the provision. And provision is also very clear. Provision also says, despite that is why Honorable Bombay High Court said and Supreme Court said that when Section 11 speaks of void marriage, and despite of Section 11, there's the central rule framed for the purpose of granting pensionary benefit recognizes
after the death of this man in 2017, as you said. Have you brought out any legal heir certificate?
Yes.
Where is that?
Legal page 27. Page 27. I was shown as the wife of the deceased
widow.
Page 27, serial number 1. Nirupama Naik. Widow, wife. So I am the wife. And other 4 children, that is 1 son and 3 daughters. Okay. 1 son, 3 daughters.
Unless you want to say information, they first wife.
1696 ସେଟା ଦିଆହେଇଥିଲା.
Only thing form 3 say that is the case of
no. If you say that by the time the first wife died prior to the retirement or
no. Retirement took place in 96. First wife died in 2016.
2006, 2006. 16.
2016. They are staying together. First wife, second wife. All are staying together.
While living a spouse, she had married. So that is how it is illegal.
Illegal means Section 11 of the Hindu Marriage Act. But so far as pension rules is concerned, Section 11 will not waive with the right of the.
So that was the decision.
Yes, only distinction between the two, let me before your lordship see the judgment. There will during lifetime of the when the first wife was alive, second wife made also claim for pension. So that means court said that will be divided equally between the two. Equally between the 2 minutes. And that was the direction mirrors of the authority mirrors, against which mirrors Union of India has filed writ petition before the High Court. High Court said no. What has been granted by the authority, that is correct. You kindly see page Page 2. Your Lordship, permit me, I can replace paragraph 2 from the very beginning.
SLP was carried out.
SLP is carried out. SLP was
Dismissed.
dismissed, yes.
Which paragraph is relevant according to?
Lordship, kindly see paragraph 5.
Yes.
5 minutes. What I am now saying the case of the central government.
Yes.
Those who have come. The Law and Counsel for the petition has contended that the Central Administrative Tribunal could not have ignored the effect of Section 11 of the Hindu Marriage Act, which provides for void marriage, and in the instant case, the respondent's second wife had married the deceased railway employee during subsistence of the first marriage. He submitted that the courts or tribunals are not supposed to make orders contrary to law, that is Section 11 of the Hindu Marriage Act, which is the mistake on the part of the tribunal. He therefore prayed for setting aside the impugned judgment and order made by the Central Tribunal. Now, my Lordship, may kindly see paragraph 7 and 8. These two paragraphs I will button your Lordship. Paragraph 7. Undoubtedly, it is clear from the reading of the above provision that Hindu Marriage Act treats the second marriage as void during subsistence of the first marriage. The contention raised by Mr. Lambert is attractive, but does not appeal to us. Then we cannot be oblivious of what is going on in the society, and a further fact that during subsistence of the first marriage, the husband performs the second marriage by practicing fraud, indulging in cheating with the second woman, who thus falls an easy prey to such person for no fault of her. Such cases have myriad. But then, since the parties are Hindus, Section 11 of the Hindu Marriage Act holds such marriage void. It is true that the courts or tribunals should not enforce or make any order or decree contrary to law, and in this case, Section 11 of the Act. But the next question is whether such a second wife, widow, after the death of her husband, in this case, the railway employee should be left to starve by giving all the pensionary and terminal benefits of his service to first wife only. This question will have to be answered with all seriousness and in the light of the revolution for emancipation of women. We feel that though Hindu personal law may not be strictly interpreted on the anvil of the Constitution of India or the fundamental rights and should not be denigrated by the courts, fact remains that the constitutional provision can be pressed into service for interpretation of law rules for achieving the ultimate object of the constitutional goal. Now the court has referred to Article 15, Article 39A. Article 15 of the Constitution prohibits discrimination on the ground of sex, while Article 39A provides for securing adequate means of livelihood for men and women equally. Article 39A provides for ensuring health and strength for women, keeping in mind the Lakshman Rekha in the matter of interpretation of provision of personal law. What the Constitution, we find that the above constitutional provisions obligate the state for uplifting the women and secure decent living for them. What we find is that Rule 75 provides for grant of pension even to the second wife, widow of a deceased railway servant along with his first wife. In our opinion, this provision of Rule 75 made by the Indian Railway cannot be held to be in conflict or in interdiction with Section 11 of the Hindu Marriage Act. On the contrary, in our opinion, for achieving the constitutional goal, as aforesaid, even for unfortunate second wife, widow, Rule 75 provides for grant of pension to her for her survival in life. At any rate, it must be seen that by virtue of Rule 75, the payment of pension to the two widows is required to be made in equal share, which clearly shows that there is no burden on the treasury or the Indian Railways by inserting this noble idea. There is no reason for us to hold that Rule 75 violates Sections 11 of the Hindu Marriage Act or that it is contrary to Hindu Marriage Act, since it does not even remotely provide for any contradiction or interdiction. We therefore hold that Rule 75 has been brought in the rule book by the Indian Railway fully in consonance with the aforesaid constitutional provision, and in our opinion, Indian Railway must be complimented for making such a provision for such type of women widows who unfortunately fall in trap of males in performing.
So that was that provision, Rule 75. Is there any such provision in the postal department?
75 is a rule under the
railways.
Yes, that was railway. Our postal department total 54 minus 54.
Similar provision is.
Yes, similar provision. Similar provision. If more than one widow.
Got that provision.
Yes.
Please pass.
And if the third lady is there? No. If the analogy has to be accepted, then if the third.
Your option is correct. That's a widows. That means that you shared equally among all.
Coming into the life of this person, the government will share the burden.
The share 100 rupees will share equally. That is not too much. There cannot be second set of penny.
So, not legitimating that marriage under the relevant provision, accepting that provision to be a proper provision, but for the purpose of this, we have to ignore that.
Share, that will share.
So, where the rigor has to be there, then what is the purpose of 11? Hindu Marriage Act.
That's a non different channel.
No, what is that? What else could be? What else could be? Other than the benefit, what else could be?
You know, in society, your lordship, no, many unrecognized second, third marriages are there.
That is
So,
different. They will not claim, no.
Here,
Here she is claiming.
where IP shop
Bigamy is there. Yes, it is.
so unless somebody comes from the complaint,
It is no more.
you know exactly.
It is no more. Bigamy is no more that way. So that is always, but
And
Rule 54, 7, sub-rule 7. Which provision you are
54.
54
for A1
7. Rule
and-
54, sub-rule 7.
Rule 54 sub-rule 7.
It's been reproduced in page 10 also of the
That
reproduction.
is where reproduction page 10 of my application. Petition.
Let us see this. 7 provision.
7, 1 and 2.
7A.
Where the family pension is
7A 1 minus.
to more widows than
54 7A Roman 1. Where the family pension is payable to more widows than one, the family pension shall be paid to the widows in equal shares. Then Roman 2, on the death of a widow, her share of the family pension shall become payable to her eligible child. We are not coming under this. Then proviso is important. Provided that if the widow is not survived by any child, her share of the family pension shall not lapse, but shall be payable to the other widows in equal share, or if there is only one such other widow, in full to her. So I am coming on the provision.
So this provision, this second marriage, maybe that sometimes what happened that, as in this case has happened, suppose the first wife has no issue at all. So
Here also,
same thing. So
yes.
with the consent of the parties,
They are staying together. With the consent, second wife,
and
second wife happens to be his sister-in-law. And let me make it very clear.
that
Youngest
is
sister-in-law.
even otherwise he is a sister.
She's a sister-in-law.
that is why it is stated that in that provision also, bigamy, for offense of bigamy, it can be instituted only on the complaint of the person.
Right, right.
So if he has no, she has no grievance,
no
then it
grievance.
matter. X, Y, Z cannot
Yes,
be
yes.
instituted.
Correct.
On the basis of FIR, it cannot be made.
Correct, man.
On the basis
Complaint.
of a complaint petition
Yes.
by that aggrieved person.
Absolutely.
Aggrieved, who is that aggrieved person, that is also defined.
Correct.
So that is why, suppose for the issue, it was a understanding and the marriage takes place for the second time. So the bigamy offense would not be attracted in view. That is the bar.
That is why the language blocks say widows. Can it be that widows? The language is very clear.
No, that is. So always it is not that suppressing the first marriage, second marriage takes place.
Yes.
Sometimes for the necessity, sometimes for this marriage takes place with the consent of the parties.
Correct.
So that is it. The petition has been filed by the petitioner, so on, so challenging the order.
Supreme Court decision also you are asking?
Yes.
I think you must have seen.
The order dated. Which order you are challenging? Annex 13.
Annex 13, man.
The order dated, the judgment and order dated, for example, order dated 17/4/2023, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack. In which the prayer of the petitioner for grant of family pension as per Rule 54(7) of the CCS.
Family pension, lifetime pension. Lifetime pension is for
of course, family pension as per Rule 54(7) of CCS Pension Rules 1972, and lifetime pension for the period from 1/4/2017 to 14/4/2017 has been torn down. Mainly on the ground that in the light of conduct rules of 1964, the contracting second marriage itself is a misconduct. and therefore the second wife is not entitled to family pension. And thus the London Tribunal did not interfere with the order dated 26/2/2019 passed by the order का reason ही
order of rejection.
Annex 11 page 35.
Annex 11 page
35.
35.
11
26/2/2019 passed by so and so
of Superintendent of Post Office.
of Superintendent of Post Office, Dhenkana Division, Dhenkana. On the ground, the existing rule does not recognize a lady as second wife of a serving or retired official, while the first wife is alive and the marriage is not annulled as per the existing law. Stop. So S.K.Sahoo Hon'Ble counsel for the petition drew our attention to Rule 54,
7.
bracket level 7 of this is which rules?
This is Central Civil Service Pension Rules 1972.
CC.
Central Service
Civil Service Pension Rules.
pension which states that where a family pension is payable to more widows than one, the family pension shall be paid to the widows in equal shares. And on the death of a widow, her share of the family pension shall become payable to her eligible child.
Kindly mention proviso to
And the proviso
yes
indicates to 7A2 indicate that if the widow is not survived by any child, her share of the family pension shall not lapse but shall be payable to the other widows in equal shares, or there is only one such other widow in full to her. Mr. South drew the attention of this court that the employee was serving in the postal department, retired in the year 1996, and the first wife died in the year 2016, and she was having no issue, and the retired employee died in the year 2017. When counsel, senior advocate, brought the citation of the division bench of Mumbai High Court, Nagpur bench, in writ petition number 4467 of 2014, judgment dated 21/2014, which taking into account a similar provision available under Rule 75 of uh, 75 of
Railways.
family pension scheme for railway servant
family pension scheme for railway servant 1964
1993.
has
Railway services pension
granted the benefit to the second wife, public widow.
May I interrupt here?
Yes.
The name of the rules is not Railway Service Bracket Pension Rules 1993.
Yeah, shut up.
Ready?
Again.
Section 11 of the Hindu Marriage Act was also taken into account while passing the impugned judgment, which deals with void marriages. It appears that the Union of India challenged the said judgment passed by the division bench in the Supreme Court in SLP so number so, which was dismissed by order dated 8/5 in 2015. The judgment passed by the division bench also the order of the Supreme Court have taken on record. Stop. You mentioned the names of the sponsors present. Copy of the writ petition has already been served on the Land Council for the Union of India. Issue notice on the question of admission indicating their
submission, my lord. May I audible, my lord?
Yes, Mr.
My lord, point I submit, let me also reflect that the CCS rule 21 also conduct rule is otherwise. What tribunals referred into in that judgment, that's why only page 46.
21.
Page running page 46, internal page of 7 of the tribunal order.
Supreme Court has kept that issue open.
That issue is open.
Left open.
The order goes like this. The leave petition is dismissed with these observation.
All right, Mr. Padi, however, drew the attention of this court to Rule 21 of the CCS conduct rules, where there is restriction regarding the marriage, which has been taken into account by the Central Administrative Tribunal. Issue notice on so and so. Matter to be placed after 4 weeks. Counter if any be filed in the meantime. Yes.
Along with me, Mr. Guchait is there.
Yes, Mr. Padi.
Mr. Guchait is along with me, Mr. Guchait.
That name I have here. Please. Yes.
Item 9.
Appearance with item.
Yes, sir, Mr. Golo. Consider appearance. Yes.
Item 9, my lord.
Already estimated and annexed to.
We disposed of. All these matters.
Item 10.
No, से 11 तो 3टा मैटर था.
9, 10, 11
How would I put it?
13.
All right. All right. Representation to be disposed of. 13 no, you said annexed
11 and 13, annexed 3.
अच्छा 11 और 13 है वो annexed 3 to be disposed of. और 9 and 10 है वो annexed 2 to be disposed of. All right.
Item number 12.
That is disposal of annexed 3.
Item 12, my lord. Cover matter, my lord.
Annexed 3 to be disposed of.
Annexed 4 is it similar?
No. Annexed 4 is our order. The basis of that.
3 is to be done. 4 रे जो order अच्छी से करते हो annexed 3 to dispose of. All right.
Item 13.
Please, my lord. My lords, the petitioner challenges the illegal occupation of the petition land by the opposite party, my lord. My lord, the petitioner is the owner of the land mentioned under Annexure 1, my lord. The Indian IOCL has been operating one retail outlet over the land since 2021. Season 2, 2008. In 2007, the petition purchased the said land. In 2014, the dealer closed the retail outlet for which the IOCL approached the Land Civil Court. There was amicable settlement under Annexure 2. The present petition agreed to accommodate the IOCL over an area of 9 square meter.
Submitted, you have sent legal notice.
Yes, ma'am. Let's look at the. So, because I have leased out an area for 900 square meter, my lords. Now he is to the IOCL is to operate its outlet within that leased area.
I filed a representation.
For the presentation, yes, lords.
No, you have to file.
You file a representation.
You have to give me
Not this legal notice.
Yes.
So we are granting you 4 weeks time to file a detailed representation.
Yes,
All right.
that will be disposed.
The prayer of the petitioner is this, when counsel for the petitioner submits that the petitioner intends to file a representation, detailed representation, highlighting the grievances in case the same is filed within a period of 4 weeks before so and so, the same shall be disposed of, time limit thereof, and the order to be communicated to the petition. All right.
Yes. I think 15. The notice under section 52. Yeah. By the one. Actually, after receiving the notice, the petitioner paid two installments, 5,50,000. And also on 26th and 24th, petitioner approached the supplementary and we will be fine with the balance amount. Or
No, 13 to notice you have received, you have given a reply, then what happened?
I have already
They are going to issue now. Headline issue. Issue of appropriate quorum to give. Whether any cause of action now survives.
now actually
You see,
please
come to the last annexure, which you have annexed, that is annexure 6.
Yes.
That is 38/2024.
Yes.
Page 32.
Yes.
So this is the letter which has been given to you by the branch manager Odisha Gramya Bank.
Sure.
And there it is mentioned that you are requested to repay the total due immediately, for failing the bank has to take further course of action. That means no action has yet been taken. 13-4 step not taken. You have been given an opportunity to repay the loan. So you meet them, have a talk, and whatever you want to do, but this court will entertain this litigation. No, it is between you and the bank. Why the court will interfere? How much balance is there? What you are to pay? What interest is there? So that is just a matter of calculation. So,
And they are not interested to the account.
So when 13-4 notice has not yet been issued, so they have not taken symbolic position, right? Once that is taken, the alternative is available with you. But now the bank is writing to is come and have a negotiation, pay this amount. So I have come here, whether we will calculate what was the due is the, what is the interest, whether that is to be done by us. Go and approach them. Go and approach the bank and say, that's all right. The writ petition has been filed. Prayer to allow the petitioner deposit rupees 8 lakhs within a 15 days and deposit the balance in 12 equal installments. It appears from Annexure 6, which is the letter issued by the branch manager Odisha Gramya Bank, that is opposite party number 1 to the petitioner, that he has been requested to pay the total dues immediately, failing which the bank has to take further action under Surface Act 2002. And as per the bank extent guidelines, including future legal reports, when it is made to the council whether any further steps have been taken after the issuance of such letter dated 38/2024, the answer was in negative. Since the petitioner, as per the prayer, is ready and willing to deposit an amount of rupees 8 lakhs and also to pay the balance amount in 12 equal installment, if any such deposit is made and any such prayer is made for the settlement of the outstanding dues, it is up to the bank to consider the same in accordance with the provisions which is available for with as per the banking rules. This court is not expressing any opinion. Same. The writ petition is disposed. Yes, next.
Item 16.
May I please also? Well, this is the second round of litigation. Earlier, the petition before this honorable court, when the Tahsildar did not carry out the order of the commissioner, and the Lordship may kindly turn to annexure 2 at please. It gives the brief of the case.
You earlier approached this court.
Approached this honorable court when the Tahsildar did not act upon the order passed by the commissioner. My Lord, may kindly turn to annexure 2. It gives the brief of the case.
No, it's all right. This was directed. What order was passed?
Your Lordship kindly see page 40. It starts from page 42.
No, come to the operative part.
Yes. And considering the allegation made by the counsel for the petition, this court finds strange in the lackadaisical attitude of the Tahsildar Puri Sadar Puri in sitting over the direction of the Land Reform Commission of Orissa Cuttack passed in 17/12/2002. This court thus disposes the writ petition with an observation that in the event there is no finality of the direction of the Land Reform Commissioner Orissa Cuttack to the Tahsildar Puri at page 14 of the brief, the direction by annexure 2 shall be worked out within a period of 2 months from the date of communication certified copy of the order, Miller.
Yeah, then what happened?
No, it was communicated, did not carry out.
So you made an representation.
Representation did not carry out, Miller.
So what representation? What is the effect of that representation?
They have.
Miller, what happened to your representation? Annexure 7, you said.
Annexure 6 and 7 series you have given.
So any communication you have received from them?
We have not received any communication. In the meantime, what has happened, Miller?
Yeah.
The Puri Miller, my Lord, knows in that because of the heritage development, Miller, our Abada scheme.
Madam Council, whether we are asking a question. When you have submitted a representation,
yes,
in terms of the direction of this court,
yes, Miller.
Anything has happened,
nothing.
So we are directing to dispose of the representation.
Yes, Miller.
It appears that the petitioner earlier the writ petition has filed this writ petition with following platforms. It appears that the petitioner earlier approached this court in so and so, and it was disposed of so and so. The petitioner submitted representation dated 6/5/2024. Before whom?
The collector.
Before the collector.
Yes.
Collector is opposite party number. You have not.
I am going to. Collector is Miller. OP number 3. 3 is the sub-collector.
He is sub-collector.
Sub-collector.
But you have
we give him to the collector.
Why have you not made collector a party?
Miller, we have also given this copy to, we have given the documents, postal receipts, Miller. We have given to all parties, including
ଆପଣ କଥା କିଏ ବୁଝିବ କଣ ଅଲ୍ ପାର୍ଟିଜ କଣ ଦରକାର ମୁଁ ଯିଏ ଆପଣଙ୍କର ଗ୍ରିଭାନ୍ସ କୁ ଇଏ କରିବ ବୁଝିବ ନା ସବୁ ଦୁନିଆ ସାରା ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେବେ ନା କିଏ who is the appropriate authority to consider your grievance? Is it collector, district magistrate Puri?
Yes,
collector, district magistrate Puri, but no response has been received. So let the collector takes a decision, so and so the time period they give and communicate the order to the petitioner within 15 days of the receipt. Serve a free copy on this collector so that he will act upon it. Okay.
Yes, Miller.
Yes, next.
Privilege.
Item 17.
Production of the certified copy. Yes.
So item 17, Arjun.
The Land Council for the petition of 6 Quran after Puja holidays.
I appeal to the bank. The two legal proceedings pending in this case. One is filed by the bank.
Yes, is from the bank. The case which is advanced.
Item number 17, you are appealing for the bank. So also files power. Which bank it is?
ICICI
Bank, which is taken on the name of the Land Council be reflected in the positive stance. Okay. Yes, next.
Item 18.
Yeah.
There are similar matters, 12 matters. Item number 18 and from 21 to 51, similar matters.
18, 21 to
1, 11, 1
হ্যাঁ।
12টা ম্যাটার আছে
ଅଛି covered matter না କଣ?
না এটা ମୁଁ ପିଟିସନର ଇନ୍ ପର୍ସନ ହିସାବରେ ଫାଇଲ କରିଥିଲି ଯୋଉଟା ଆପଣ ଡାଇରେକ୍ସନ
Agency order ଟା କାଇଁ?
ନାଇଁ ସେଇଟା ସାର୍ ଡାଇରେକ୍ସନ ଦେଇଥିଲେ ଯୋଉ ସେଥିରେ
So what is that order? Please give us that.
ମୁଁ ସାର୍ ଆଡମିନ୍ ତ ସେଟାରେ ସେଟାରେ
What is the earlier application?
ହଁ ସେଥିରେ ଏନ୍ଏଚଆରସି ଏନସି
Mr. Council, what is the order dated? What is the number?
23044
WPC
23044
230
44 of 2024
2024 dated
24/9/2024
24/9/2024 same order.
ନାଇଁ ନାଇଁ ସେମ୍ ଏଇଟା ଏଇଟା ମୁଁ କହୁଛି ମୁଁ ପିଟିସନର ଇନ୍ ପର୍ସନ ହିସାବରେ କରିଥିଲି ଏଇଟା ଆପ୍ରୋଚ କରିବା ପାଇଁ ଅବଜରଭେସନ କରିଥିଲେ ଏମାନେ ସବୁ ପ୍ରୋଜେକ୍ଟ ଆଫେକ୍ଟେଡ 19 people approached ଆଜି 12ଟା ମ୍ୟାଟର ଉଠିଛି
What is your prayer?
ୟେସ୍ ଏମାନେ କମ୍ପନସେସନ ପାଇନାହାନ୍ତି 2006-7 ପରେ ଗୋଟେ କମ୍ପାନୀ ସିଏସସି ସେଟା ଆକ୍ୱାର କରିବା ପାଇଁ କରିଥିଲା ଇଡିପିଓ ତାକୁ ଆକ୍ୱାର କରିଥିଲା 2012 ମସିହାରେ ଏନ୍ଏଚଆରସି ଆଉ ଏନସିଏସଟି ଏମାନେ ସେଠି ଯାଇକି ପହଞ୍ଚିଲା ପରେ ମୋର କେସ୍ ମୁଁ କରିଥିଲି ସେଠି ଏନ୍ଏଚଆରସି ଆଉ ଏନସିଏସଟି
ଆପଣ କଣ କେସ୍ କରିଥିଲେ?
ସେ ଏମାନେ କମ୍ପନସେସନ ପାଇନଥିଲେ କି ମୁଁ ଏନ୍ଏଚଆରସି ଆଉ ଏନସିଏସଟି କେସ୍ କରିଥିଲି 2012 ରେ
Whatever it may be, the petitioners have not, according to you, the petitioners have not got any compensation.
They have 30% to the collector. They have not repented.
ରିପ୍ରେଜେଣ୍ଟେସନ ଏଇଟା ରିପ୍ରେଜେଣ୍ଟେସନ ପାର୍ଟରେ ଯିବନି ସାର୍ ଟିକେ
Page 130.
ମୁଁ ଟିକେ କହିଦିଏ ସାର୍ ଫ୍ୟାକ୍ଟ ଥିଲା ଏମାନେ 2012 ଯେତେବେଳେ ବାହାରରେ ଡାଇରେକ୍ସନ ଦେଲେ ଏନ୍ଏଚଆରସି ଆଉ ଏନସିଏସସି 2014 ଡାଇରେକ୍ସନ ଦେଲା ପରେ ସେ କମ୍ପାନୀ ଭାନିସ୍ ହେଇଗଲା ସିଏସସି କମ୍ପାନୀଟା ଆଉ ଆସିଲାନି ତାପରେ ସେମାନେ 8 ବର୍ଷ ଚୁପ୍ ରହିଲେ 2022 ପୁଣି ଆକ୍ଟିଭ କଲେ ସେତେବେଳେ ପୁଣି ଏମାନେ
ଦେଇଛନ୍ତି
ଏଜୁକେସନ କଲା ପରେ ଏମାନେ ଏଜୁକେସନ କଲା ପରେ ଲୋକମାନେ ସେ ରିପିନାନ୍ସ ଦେଲେ
3/2024 ରିପ୍ରେଜେଣ୍ଟେସନ ଉପରେ କିଛି ଆକ୍ସନ ନିଆହେଇନି?
ରିପ୍ରେଜେଣ୍ଟେସନ ସେଟା ଆଉ କିଛି କରିବେନି ମାନେ ସାର୍ ରିପ୍ରେଜେଣ୍ଟେସନ ଇଏ ହବନି ଏନ୍ଏଚଆରସି
11, 12, 23, Annexure 5.
ସେଟା ରିପ୍ରେଜେଣ୍ଟେସନ
This is a letter of he himself submitted for everyone.
ହଁ ସେଟା ସେଟା
Activist.
The individuals would
Apply for it.
କଲେକ୍ଟରଙ୍କ ଡାଇରେକ୍ସନ ନାହିଁ ଏଇଟା ମିସଗାଇଡ୍ କରୁଛନ୍ତି
କିଏ?
କାଉନସିଲ କରୁଛନ୍ତି
Council କିଏ miss-
ମୁଁ କହୁଛି ସାର୍ 127 ଦେଖନ୍ତୁ
Petitioner has filed the Mr. Council, whether the petitioner has filed any representation for ventilating his grievance.
ସାର୍ ମୁଁ ଟିକେ କହୁଛି ଆପଣଙ୍କୁ
Asking a question.
ୟେସ୍ ୟେସ୍
Where is the representation?
ଏନ୍ଏଚଆରସି ର ଡାଇରେକ୍ସନ ଏକ ନାଁ ଅଛି
Representation.
ଏନ୍ଏଚଆରସି
Where is the representation?
ରିପ୍ରେଜେଣ୍ଟେସନ ଏଟା ହବ ନାହିଁ
File the representation.
ସାର୍ ସେମାନେ ବହୁତ ସାର୍ ଗରିବ ଆଦିବାସୀ ଲୋକ ମୁଁ ତାଙ୍କ ପାଇଁ ପର୍ସନାଲି ଫାଇଲ କରୁଛି ସାର୍ ଟିକେ ଟାଇମ ମତେ ଟିକେ ସାର୍ ମତେ ଟିକେ ଶୁଣିବା 5 ମିନିଟ ସମୟ ସାର୍ ଏନ୍ଏଚଆରସି ରେ ସାର୍ ମୁଁ ନିଜେ ଗୁଡା ସେମାନଙ୍କୁ ସପୋର୍ଟ କରି କରୁଛୁ ସାର୍ ଗରିବ ଆଦିବାସୀ ଲୋକ ସାର୍ ଟିକେ ଟାଇମ ମତେ ସାର୍ ଏନ୍ଏଚଆରସି ସାର୍ ଟିକେ ଏନ୍ଏଚଆରସି ର ଡାଇରେକ୍ସନ ପରେ ଦେଖନ୍ତୁ ସେମାନେ ନାଁ ଅଛି ଏନ୍ଏଚଆରସି
19 years.
କଣ କରିବା
Item number 19.
ଏନ୍ଏଚଆରସି ମାନେ ଏଇଟା ରିପ୍ରେଜେଣ୍ଟେସନ ସାର୍ ହବନି ଟିକେ ଶୁଣନ୍ତୁ କାହିଁକି
Item number 19.
12ଟା ଆଇଟମ ଅଛି
land in notification 4-1 the land notification was notified,
Representation.
but 6-1 it has not notified. But the land is inside the campus of the IFCO. And that's why the compulsion we made a representation by Annexure
Annexure 3.
3
Yes.
and also the leaders notice Annexure 4, Annexure 6, Annexure 5 and Annexure 6, 31, 30. But they are not considering not paying the commercial. The land is inside their campus now. And but we are paying the land revenue that I have also annexed.
19.
Yes. Annexure 2 is the my RR. Annexure 3 is the forward notification. Annexure 3 is the 6 notification where kindly let's
Have you got your compensation?
till that I got the compensation. I was asked to appear before Delhi in their office, and I went to Delhi. And that immediately will take the step, but they are not taking the step for which I have also given the previous notice by the Annex 6, Annex 5 also.
Give a representation, not reader.
Representation of Annex 5?
Annex 5.
Yes, madam.
Let us see that. No, this is
That
not
is
detailed.
not.
Give a detailed representation. We are giving you opportunity to give.
You just convert the pleader notice to a representation and file it.
Just-
I think that is more different.
Because it's also the thing I
that this is the prayer of the petitioner. The petitioner will file, in case the petitioner files the
Yes.
representation within a period of 4 weeks from today, giving all the details and documentary evidence. Same shall be considered by the so and so, within a period of so and so, and the order shall be communicated to the. Yes.
Item number 20. May it please your lordship. Your lordship, this is relating to the payment of the compensation towards the structural cost, your lordship.
So one application would be withdrawn today morning
Yes, your lordship.
of the similar nature.
Yes, your
What
lordship.
happened in this case?
This case, your lordship, that case, your lordship, there were some mistakes, so
All right.
it was withdrawn.
Actually, my lord, your lordship, this was the 9 number of cases earlier. The correct fact has not brought to my lordship, and no notice of the issued the initial. Your lordship, in that the 9 cases has directed the general manager NHA to pay the compensation amount. Actually, my lord, as per the scheme of the NHA Act 1946, only the persons who are interested in the land, those who are entitled to get the compensation, they will pay it as per PG 1. And the collector has no authority to direct the exercise of being the magistrate, district magistrate to pay the compensation amount. And lordship, actually, I have instruction to appear in all cases. And lordship, I have filed memo. If this matter may be taken up, and other similar matters perhaps can, all the matters can be taken up together after.
When those matters are there.
I'll give them.
List has been given.
Okay. So, really, opportunity I'm dealing the detail I will.
So give the name, your appearance memo, whatever it may be.
My lord, I'll file no problem. I'm giving my appeal. I have instruction.
These are all the cases which is sub judice now.
No, disposed of.
Or disposed of. So what do you want to know?
My lord, in all cases, I have instruction to file application for modification because they are entitled to compensation.
After you file only, we can see.
And in this case also, I have instruction to appeal.
All right. This one you can say.
Otherwise, it will be disposed of in the light of those decisions.
My again, my lord,
File.
You lord, I beg, frame my lord.
Have you got the order copy with you?
Yes, your lordship.
Same disposal.
My lord, appearance of
Appearance. Yes, next.
My lord, please give me opportunity.
File your interim application if you want to file in all these cases. Yes, next.
Item number 32.
Year.
32 Annex 3. Disposal.
Annex 3. Representation to be disposed of. Yes.
Item number 33.
Yes. I am pleased, your lordship. The petitioner has availed two house building loans from the opposite party's bank. And due to pandemic situation, he could not able to deposit the EMIs. So the entire loan amount has been
E-auction sale notice has been issued. E-auction sale notice has been issued.
Notice
Mr. Counsel, e-auction sale notice has been published in Times of India.
Yes, ma'am.
Right?
Yes, ma'am.
And on 4th September 2024.
Yes, ma'am.
So, where is that e-auction sale notice?
That has not been annexed, but that paper we have.
That is the reply given by the bank to you that authorized officer has given. Please come to that page number 20.
Yes, ma'am.
It is mentioned that the e-auction sale notice is published in Times of India and Samvad Delhi on 4th September 2024.
Yes, madam.
So what happened to that?
But prior to that, I have filed a representation under Annex 4, stating that the exact amount be given to me so that I can settle the matter
You have
under
to
the
challenge
one-time
the
settlement
e-auction
scheme.
sale notice.
Yes,
Have you challenged the e-auction sale notice?
auction sale notice
Before the
by way of
forum.
this paper publication. Not personal notice has not been.
Notice टा कहीं आपण गोटे कोन बैंक रो कम्युनिकेशन बैंक पूरा लिखुचंती जे ई ऑक्शन सेल नोटिस टा टाइम्स ऑफ इंडिया संवाद रे 4 तारिख दिन 4 सेप्टेम्बर 2024 रे पब्लिश हेची. So you should have annexed it and there is a forum available to you to challenge that notice. So you have not वर्तमान ए बैंक लेटर तो कोन आनी दउचनी हम.
No, under Annex 4, I have intimated that let me know what is the exact amount to be settled under the one-time settlement scheme. But they have not given
this read. Through this read petition, we will come to know what is your exact status.
Yes.
We will say for that.
No.
Then
I have given.
You go to the bank and get it.
Yes, I have given under Annex 4 to the bank. That you give the exact amount along with my principal interest, whatever it may be, so that it can be settled under the one OTS scheme.
With a prayer for a direction to the opposite party to disclose the exact amount to be deposited by the petitioner. As per
Annex 5.
The document indicates that e-auction sale notice has been published in Times of India and Sambad Daily newspaper on 4th September 2024. The copy of the e-auction sale notice has also not been annexed to this writ petition. The alternative forum being available with the petitioner to challenge such e-auction sale notice, we are not inclined to entertain this application before those decision of the Honorable Supreme Court. It is dismissed. Yes, next.
Pardon me, Lord. Lord, the OJC matter, Lord. And my Lord, the
Did a similar order make first, Lord? 32 we have disposed of it.
Disposed of. Annex 3 to be disposed.
My Lord, they disposed. Chipra,
Next.
Item 34. Item 34. I'm challenging the order at Annexure 11, wherein the learned district collector has denied to exercise its jurisdiction to give employment under Clause 8 of R&R policy to the petitioner number 2. The land acquisition process took, the notification for land acquisition was issued in the year 1989. Thereafter, the petitioner's father has received compensation.
What happened to your representation?
Representation has been rejected under Annexure 11, which is what I'm challenging, which is at page number 37, Annexure 11. The operating portion is the second last para, wherein the learned collector has held that the Honorable Supreme Court, by their orders in SLP 6933 of 2007, have constituted a claims commission to decide upon the compensation and other statutory benefits for the land outstays families of 10 villages, including the village of the petitioner, that is Maling. This court lacks jurisdiction to decide the matter. Now, my grievance is that I had approached the Claims Commission. Lordship may have a glance at the order passed by the Claims Commission declaring my prayer as infructuous. That is at page 28, Annexure 8. I had approached the Claims Commission before, and this order has been passed ex parte also. Now,
where is the order of the
Annexure 8,
Annexure 8
page 28. Page 28, Lordship may see 1/6/2022. Serial number 2, civil case number 6 of 2019, Sarojini Dandasena, entered appearance. Matter was heard at length.
That is an information that
Information you have got.
It is an information, but the fact remains that my civil case number 6 of 2019 has been
No, you have to file the order.
File the order. File the order.
File that order. Let us see.
I'll file that order.
It appears that the petitioner has challenged the order dated 22/2024 of the collector Sundargarh, that is opposite party number 3. In rejecting the representation, entirely holding that the Honorable Supreme Court of India by orders in SLPC
8933.
6933.
now.
6933.
6933. I have a copy of that.
2007 have constituted Honorable Claims Commission to decide upon the compensation and other statutory benefits for the land outees family of 10 villages, including the village of the petitioner, that is Balinga. And therefore, the collector lacks jurisdiction to decide the matter. And the petitioner can approach the Honorable Claims Tribunal for getting the reliefs. This order was passed in this case number so and so, 17 of 2024. Say annexure 11, page 37. The Land Council for the petitioner submits that earlier the petitioner approved this claims tribunal, claims commission in civil case number 8 of 2019.
6 of 2019.
Sorry, 8 na 6? 6 of 2019. And the matter has been disposed of. But the order passed by the Claims Commission in the said case has not been annexed to this application. Rather, the Land Council relies on what has been mentioned in the communication made by who has it in this council has mentioned.
Council for MCL.
Communication dated 5/7/2022 by annexure 8. Let the Land Council for the petitioner file the copy of the order passed in civil case number 6 of 2019 put up this matter after the ensuing puja holidays. Yes.
Can I address one thing, Your Lordship? There is a difficulty.
Yes, next.
Item number 35.
But in this case, I have challenged the order of the DRAT under annexure 16 at page 103. But fact is like this. Section 13(2) notice was issued for rupees 51 lakhs. Then the only residential building was sold in 50 lakhs or more. She filed 17 application.
Please come to that order.
Madam, Your Lordship, kindly see the first order, that is
please come to that order which you are challenging before us. Annexure 16 you are challenging.
103, page 103.
1034.
103. Annexure 16.
Right. Please read it out.
But it appears that the compliance of the order regarding pre-deposit dated 2/5/24 is not met.
Yes.
Full amount as required under the order dated 2/5/24 is not deposited.
Yes.
Accordingly, appeal is dismissed, being not maintainable.
Yes.
Amount already deposited may be refunded to the appellant in accordance with law.
Yes.
Your Lordship kindly see the order dated 2/5. That is Annexure 14, page 89. Page, operating portion is at page 91. Having considered the submissions, so Lordship got it?
Yes, yes.
Having considered the submissions made by the learned counsel for the appellant, I found it appropriate to reduce the pre-deposit amount to 35%. Accordingly, IA number such and such is disposed of with the direction that the appellant should make a payment of 35% of rupees 72,16,105 as pre-deposit within a period of 6 weeks. My lord, he deposited 17,50,000. But this the 35% of this amount, 72 lakhs amount, is coming 25 lakhs. 25 lakhs or more.
Here you deposited 17 lakhs.
Correct? 17 lakhs 50,000. So balance 7 lakhs or more. I pray your lordship grant some time so that he will deposit. Because his appeal has been dismissed.
No. How can we know that you have deposited 17 lakhs?
But I have given the drafts. Copy of the drafts. Annexure 14A.
And that too within that period of 6 weeks. Because this order
subsequently
এই অর্ডারটা পাস হলা 2/5/2024 রে
subsequently Lord Chairperson extended the period. That orders I have been closed. You will also kindly see page 92.
Let the balance be deposited by 13th of August.
No, thereafter it is extended.
Again. No, this is one extension. Matter. You
will also kindly see by order dated 18/7
Mr. Das, প্রথম অর্ডারটা আপনি যেটা দেখাইলে সেটা পেজ 91 রে এটা পাস ହେଇଛି 2/5/2024 রে ଆପଣଙ୍କୁ କୁହାଲା 6 ସପ୍ତାହ ଭିତରେ ଡିପୋଜିଟ କରିବା ପାଇଁ ତାପରେ ଆପଣ କେତେ ଥର ଏକ୍ସଟେନସନ ପାଇଛନ୍ତି?
ଧର 3-4 ଥର
ଏଇ ଯୋଉଗୁଡାକ ଆନେକ୍ସର 15 ସିରିଜ ରେ
Annexure 15 series re time is extended. But the actual difficulty is that the conducting council he intimated that 35% of 13 notice.
No. The order clear.
That is why there is some mistake and some delay. However, Lord Chairperson has extended the time. I am not on that matter. My only prayer is your lordship kindly grant some time so that she can protect her valuable property. But after taking over the physical possession and selling the property,
for that we have to, once we have to set aside the order, the other side is to be noticed. So Indian Bank, who is appearing for the Indian Bank?
Bank, my lord, they are in Calcutta, they other lawyers.
No. Bhubaneswar main branch.
Bhubaneswar main branch, but in the appeal is filed in
it's all right, but here the parties are Bhubaneswar and 4 are Bhubaneswar, and who is that? Gauri Shankar?
She is the auction purchaser. May I pray one thing, my lord, subject to my lord. Your lordship may direct along with the balance amount.
No, we cannot. Without hearing him, we cannot.
Along with the balance amount by way of draft, I will file one application before the Lord Chairperson because on 11th, because the holidays are there, Puja and Kali Puja. On 11th, I will approach the Honorable Chairperson. He will consider it sympathetically.
When this order was passed, 6/9/24.
6/9. I got the certified copy. You will also kindly see on 19/9, page 105. Because Puja holidays are there in Calcutta, Meerut, reopening day is 4th November.
But without hearing the other side, how can we set aside the order? The Learned Counsel for the the petitioner has challenged the order dated 6/9/2024
Under
passed
Annexure 16.
under Annexure 16 passed by the Debts Recovery Appellate Tribunal at Kolkata in appeal so number which arises out of so wherein the Learning Tribunal has been pleased to dispose of the interim application and vacated the interim order.
Not the interim order. No interim order was passed.
The interim order, if any, as a change.
That IAs.
In dispose of the insurance and on the ground that the full amount as required under the order dated so has not been deposited, and therefore the appeal was dismissed, being held not maintainable, and the amount already deposited was directed to be refunded to the petitioner in accordance with law. The Learning Counsel for the petitioner drew the attention of this court to the order dated 2/5/2024 passed by the Law and Appellate Tribunal, wherein it has been held that the to be appropriate to reduce the pre-deposit amount to 35%, and accordingly the direction was issued that the petitioner should make payment of 35% of rupees 72,16,105 as pre-deposit within a period of 6 weeks. The Learning Counsel for the petitioner submits that though the amount as per the order dated 2/5/2024 comes to 25 lakhs and odd, but the petitioner deposited rupees 17 lakhs and odd.
17 lakhs 50,000.
17 lakhs 50,000. As per the subsequent orders passed extending the deposit period, but and the petitioner is now ready and willing to make the entire deposit as per the aforesaid order dated 2/5/2024 and stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice for opposite parties number 3, 4, and 5 be filed by Monday by speed post with proof of delivery. The matter be listed immediately after the ensuing summer holiday. Yes, sorry, Durga Puja holiday.
But I have filed one IA. Your Lordship may observe that no third party interest be created over the property in meantime.
Let us see that. Let them appear. Yes.
Your Lordship may issue notice so that
we have issued
notice.
We are issuing notice. You in interim petition number issue notice could not accept one set of this. Yes, next. That's
Special notice for judgment. Disciplinary forum 2020.
Considering the testimony of the reliable eyewitnesses, while motive may strengthen a case based on circumstantial evidence, it is not essential when credible direct evidence exists. Even though the exact motive, that is the theft of the hen, may not be fully proven or be looked at as trivial, as argued by the Learned Counsel for the appellant, the overwhelming evidence leaves no room for doubt that the attack was premeditated, and the appellant is conclusively proven to be the author of the crime. Therefore, the conviction of the trial court under Section 302 IPC is fully justified. In view of the above discussions as above, in our considered view, the prosecution has been able to prove its case beyond all reasonable doubt. the judgment and order of conviction dated 11/12/19 passed by the learned First Additional Sessions Judge Rourkela in Sessions Trial number 12 of 2017 is found to be legal and justified, and the conviction of the appellant is confirmed there.
I agree. Yeah.
Representation, annexure 3. Next.
36.
Item number 36.
Representation, annexure 3 to be disposed of.
Annexure 3.
Yes.
Item number 37.
Yes. Yes, Learned Counsel.
In this case, my lord, I am challenging the order of the Learned Central Administrative Tribunal, my lord.
Which is that order? Which is that order?
Order, my lord,
Annexure?
17. Ninth.
Annexure 1. Annexure 1. Here, my lord, the Learned Tribunal has rejected my application for stay of the departmental proceeding. And I had filed that one because my application by the before the disciplinary authority alleging malice against the inquiry officer was rejected. And I came before the tribunal against that order, my lord.
No, you have been issued with the second show cause notice.
Beg pardon.
You have been issued with the second show cause notice after the inquiry.
Yes.
So,
I wanted that the inquiry officer should be changed. As against that, I made an appeal. That appeal was rejected. And I approached the Honorable Tribunal. Honorable Tribunal did not grant me initially any interim order and asked for the show cause. So after getting the show cause, my lord, he has passed this order. You will also kindly come to page 21, paragraph 5. I would just like to place before to lordship paragraph 5. The ground taken by the applicant is that the inquiry officer did not allow for inspection of the original listed documents, and that the documents listed were all Xerox copies cannot be sustained since the same are in custody of the CBI, which has registered a case and investigating it, and all original documents are in their possession. Documents have been attested by the competent authority as a true Xerox copy. Applicant alleging non-supply of the original documents and a non-payment of the subsistence allowance, and also the IO carrying on inquiry in spite of that.
where is the bias ground? You are, please come to the grounds which you have taken that has been quoted in that order of the Learned Tribunal in paragraph number 3. Page number, please come to that.
Yes,
Page number 20.
Yes.
So nothing about that. And you just come to the operative part, that is paragraph number 5. Just read it out.
Paragraph 3, my lord.
No, paragraph 3 we have seen that there is no bias ground against that inquiring officer. You come to paragraph number the next page, page 21, paragraph 5.
Paragraph 5.
Yes,
I was just placing that one.
Just please it.
The grounds taken by the applicant is that the inquiry officer did not allow for inspection of the original listed documents, and that the documents listed were all Xerox copies cannot be sustained since the same are in custody of the CBI, which has been registered as a case and investigating it, and all original documents and in their possession. Documents have been attested by a competent authority as a true Xerox copy. Applicant alleging non-supply of the original documents and non-payment of the subsistence allowance And also the IO carrying an inquiry despite that has submitted one bias petition. Competitive authority has rejected the same as being baseless and unsustainable. This tribunal doesn't find any illegality on the part of the respondents in doing so. It is also contended by the learned counsel for the applicant that due to non-announcement of the subsistence allowance, applicant is in a hard pressed to attend the inquiry. It is seen from the record that the headquarters of the applicant being during suspension is fixed at Lachipeta, Koraput. Inquiry is also being conducted in Koraput. Therefore, this tribunal doesn't accept the said argument for staying of the disciplinary proceeding.
Yes. So how do you say that?
My humble submission before your lordship is, at this order says, my lord, the tribunal has taken note of the fact, one first fact, that I had asked for inspection of the original documents to the particular document.
Yes.
Now the tribunal says the agrees with the finding of the disciplinary authority that the applicant was supplied with the attested copy and it was in the custody of the CBI, therefore that cannot be inspected. Now that is the first round. Second is, I had raised that objection that I am not getting the subsistence allowance. Even that has not been, that was rejected by saying disciplinary authority did not accept that one, and the tribunal is saying that inquiry is conducted at a particular place. Therefore, non-payment of subsistence allowance also doesn't create any prejudice to the man. My humble submission before your lordship is, both the account the tribunal has failed to appreciate my case. First is, your lordship may kindly turn to that document that I was asking for, inspection in original, that I have annexed my lord to my petition. Your lordship may, original application also I had annexed that one. That document your lordship may kindly turn to page
Now, if attested copies of those documents were given to you, then how you are prejudiced?
My lord,
because the original documents admittedly with not the inquiring officer, those are seized by the CBI. So, in what way you are prejudiced? And the copies have been supplied to you. Those are attested copies. So they are also relying on the very documents, and you are also relying on those very documents. So, is there any difference between anything in that original documents and the, in what way?
My lord, the document that I asked for inspection from the CBI custody was generated at 12th mid of the night, and that was Xerox copy. The inquiry officer has been supplied a Xerox copy.
Yes.
And there is a signature of mine. Rati Varata Vele, I have never signed any document. And generation of that document shows on the face of it was generated at 12 of the night. Therefore, and that is the basic document of their, the foundation of their entire inquiry.
So what is that document?
That document, my lord, I am showing you. Sorry.
Somebody says the court, it is said that the original documents are not available with me, and Xerox copies are available, and you have also been supplied with the attested copies as 2 copies. So can it be said that by passing the order, the officer is biased?
My lord, the rule is I am placing before your lords, my lord. Page 37, your lordship may kindly.
Yeah. Yes.
7.15.
7.15.
15,
yes.
that the documents containing evidence in support of the allegations which are proposed to be listed for production during the inquiry shall be carefully scrutinized. All material particulars given in the allegations, such as date, names, marks, figures, totals of the amount should be carefully checked with reference to the original documents and records. In this case, my lord, particularly the person who attested that one he is not the disciplinary authority, my lord. He is not the disciplinary authority, my lord. And the IO has been supplied with the Xerox copy. And in that context, my lord, Lordship may kindly come to page 34. The CCA rules, my lord, says this rule 14, I'm relying on paragraph 11 at page 33 and thereafter that para 12, my lord. Can I just place it paragraph 11, my lord?
Which
at page 33, my lord. Page 33, my lord.
33, yes.
The inquiry officer shall, if the government servant fail to appear within specified time or refuses or omits to plead, require the presenting officer to produce the evidence by which he proposes to prove the article of charges and shall adjourn the case to a later date, not exceeding 30 days, after recording an order that the government servant may, for the purpose of preparing this defense, inspect within 5 days of the order or within such further time, not exceeding the 5 days, as the inquiring authority may allow the documents specified in the list referred to in sub-rule 3. Submit a list of witnesses to be examined in this way. Note, if the government servant applies originally or in writing for supply of the copies of the statements of the witnesses mentioned in the list referred to in sub-rule 3, the inquiry authority shall furnish him with such copies as early as possible, and in any case not later than 3 days before the commencement of the examination of the witnesses on behalf of the disciplinary authority. Giving a notice within 10 days of the order or within such further time, not exceeding 10 days, as the inquiry officer may allow for the discovery or production of the documents which are in possession of the government, but not mentioned in the list referred to in sub-rule 3. Note, the government servant shall indicate the relevancy of the documents required by him to be discovered or produced by the government. The inquiry authority shall, on receipt of the notice for discovery or production of the document, forward the same or the copies thereof to the authority in whose custody or possession the documents are kept, with a requisition for the production of the documents by such date as may be specified in such requisition. In this case particularly, inquiry officer rejected it at this threshold. He had the authority to ask to make a requisition.
No, my lord has put a very pertinent question to you. When you have been allowed to verify the documents in the form of Xerox copies, true copy Xerox. You can put question on that.
No, that Xerox copy is always
question on that.
The Xerox, my lord, from the original, they are saying CBI is
varying from the original. You say that the original is different than the Xerox. The document which is supplied to you is different than the original according to you.
My lord, my solution is, it is something like this, my lord. Because that document show that I had signed it.
And signature is irrelevant. Question is that is there anything discrepancy in the contents?
That is what I want to discover.
Question,
because signature is not a thing.
How do I discover that one, my lord? If they are saying the original has been seized by the CBI.
No, you can put suggestion. You can put that this is the documents.
The true copy has not been attested by the disciplinary authority, my lord.
No,
some other authority who is nowhere related to the inquiry proceeding, my lord.
No, this order.
He has not true copy has not been.
CBI case, you are a party or not?
I'm like, what the certified copy? Well,
what the certified copy you are referring with that?
Well, one thing. But in a departmental proceeding, unless I requisition the documents, my lord, I will not be allowed.
You are going to the inquiring officer's role.
Right.
You are going to the inquiring officer's role.
Yes.
The inquiry officer can send a requisition to get the documents. Now that you have already been supplied the document, you differ from the kind of document supplied to you, saying that it is not the one that you are referring to.
Or the original document may be different.
Is a different one.
Yes, my apprehension, it is not apprehension. I am sure that since I have not signed it and my signature has been shown in the document, therefore it is a manipulative one. That is why I wanted that I should see I must be allowed to see the original, which is said to have been seized by the CBI.
Victim brother says that when the original document is in the CBI court, let us say it is in the CBI court, so you can apply for the certified copy.
I will not be allowed to exhibit it in the inquiry, my lord.
Yes.
I will not be allowed to exhibit in the inquiry.
Why?
No, my lord, that is the procedure. The procedure prescribed has to be followed by the process they have. The rule has its own procedure, my lord. Someone has to rely upon a document, then make a requisition.
Inquiry officer application before the inquiry officer seeking to verify certain document, and if the inquiry officer finds that those particular documents are in the possession of some third authority, he will make a requisition. Now you are not stopped. Principle of natural justice demands, if a particular document has been assigned to you or a copy of thereof has been assigned to you, and you find that this is somehow different from the original, and you have the certified copy, you can file it. Let them say no. Let them say no.
Only one submission to your lordship, my lord. Your lordship knows this inquiry procedure.
Yes.
Unless someone, I cannot produce it as a defense document.
How can you say?
Unless the IO allows me, yes, I cannot produce. I can produce it. Yes, my lord. If it is within the power of the IO,
so the entire CCA is one part, and the cardinal principle of disciplinary action is based only on principle of natural justice.
My lord, my submission before the rule prescribes the rules. There is a prescribed procedure.
Grounds you are.
Can the IO say? I will not. I will not.
It's very easy to say that somebody.
Then he has to assign the reason. Why?
No, that he is assigning the reason that he has not assigned the reason. Sir, once the two copies are handed over to you, why you will go for the information? Why you will go for it? The vetting officer has produced the document and he is certifying it to be the true copy. If anything goes wrong, it will be on the presenting officer. If it is not by the authority, the presenting officer will be held liable.
Presenting officer?
Presenting officer, sir.
Yes.
You are not able to understand who is presenting officer.
Yes.
The officer who represents the authorities.
Yes, the Lord President.
Right?
Yes.
So these documents are filed by the presenting officer once you ask for the document.
Yes.
And it is a true attested copy.
Yes.
In case anything goes wrong, not and contrary to your case, he will be held responsible.
My problem is, how do I prove that it is contrary? Or it is false? You have the document on your own, supplying and relying upon a document.
Yes. The council you produce on your own.
On your own. If you differ, you will produce on your own.
That observation is that I have no problem.
Yes.
But by for my own,
your time will come, defense will come, you simply some suggestion to witness that this is not the document that I am referring to.
Again,
the document does not bear my signature. Can't you put this question to the witness? Leave it. When your turn comes, you file it. This is the certificate copy which I want to file. Your turn will come as defense evidence. Then we'll file.
If it is a manipulated document, how do I prove it?
Yes,
that is my problem.
Questions, sir.
One part. Second part, before you lordship, my lord. You lordship, may kindly see. I was suspended.
The subsistence allowance.
Which part?
Subsistence allowance.
Yes.
Yes.
I was suspended on 31/12/2020, my lord.
Yeah.
This case, my lord, charge sheet was issued in 2023, my lord. The rule says the FRSR, my lord, which are statutory in nature, my lord. says, my lord, if the suspension,
Did that is so.
beg pardon, my lord,
Who was that?
FR 53, my lord, your lordship, kindly. FR is certain. FR is certain.
Yeah. Suspension chapter ଅଛି ସେଟା
53, my lord.
53.
53. 53 Roman 2.
In the book, so that you'll find it out and put a flag mark.
My lord, I have my annexure, your lordship.
Annexures?
It is there.
Annexure?
Annexure, my lord. Annexure 7, my lord, page 38. What's again?
FR 53.
Yes.
'53 Roman 2 at page 38, my lord.
Roman 2.
Yes, Roman 2, my lord. Roman 2, in case of any other government subsidy.
2A.
A subsistence allowance, Route 2A says, Roman 2A says, the subsistence allowance at an amount equivalent to the leave salary, which the government servant would have drawn if he had been on leave on half average pay or on a half pay. And in addition, dearness allowance admissible on the basis of such leave salary, provided that when the period of suspension exceeds 3 months, the authority
90 days, right.
which made or is deemed to have made the order of suspension shall be competent to vary the amount of the subsistence allowance for any period subsequent to the period of first 3 months as follows. The amount of subsistence allowance may be increased by a suitable amount, not exceeding 50% of the subsistence allowance admissible during the period of the first 3 months, if in the opinion of the said authority, the period of suspension has been prolonged for a reason to be recorded in writing, not directly attributable to the government servant. In this case, admittedly, my lord, after 2 years of my suspension, 2 or 3 years, they have issued the charge sheet.
So you are receiving 50% and not counted.
50%. That was to be been revised to 75%. In this case, my lord, it is my lord.
The entire proceeding should be quashed. Disciplinary proceedings should be quashed merely because you are getting 50% and the authority has discretion to enhance it, and they have not enhanced. And you have also not filed any representation to that effect. On that ground, the entire disciplinary proceeding would go.
My submission is, my lord, I raised that question before the disciplinary authority, before the IO. Yes. And every time I'm saying, I'm unable to maintain myself, my family. Yes, I'm not able to engage a defense assistant. Therefore, please enhance my subsistence allowance. And that has been rejected by assigning no reason, so to say.
Learned counsel, you know that is not a ground on which the entire proceeding will be initiated. Again, some factual aspect has to be seen whether during this period he was gainfully employed, he is there or not. Many aspects are there. Leave it to the authority on that. This is not the ground on which you expect the entire proceeding to be initiated. You are getting 50%, 75% they can go. If it goes beyond 90, they can go for, you may get up to 75%.
It is a statutory rule. Yes. And, my lord, in this context, my lord, with your lordship's kind permission, Can I just?
It is there in every group, sir. It is there in every group. It is there in every group. In all departments. It is a.
And in case of violation of that, my lord, what will happen? But your lordship will kindly see. My lord, what is the purpose of granting the subsistence allowance?
It's a subsistence allowance. What is the question of purpose? It is subsistence allowance.
My lord, be kindly just allow. He is facing 2 criminal cases, 2 CBI cases at Bhubaneswar, 2 departmental proceedings at Malkanagiri. And addition to that, one OPDR proceeding has been instituted against the man, and the man is being paid 50% of the subsistence allowance, when there is rule is that it should have been enhanced to 75%. Yes. And you will also may kindly see this judgment, my lord.
Now, what is the stage now?
Yes.
But the inquiry officer is going and examining all the witnesses, my lord. Every 2 days, 3 days, he is fixing the inquiry. Paragraph 6, my lord. You will kindly come to that. An order of suspension is not an order imposing the punishment of a person found to be guilty. It is an order made against, before he is found guilty, to ensure smooth disposal of the proceeding instituted against him. Such proceeding should be completed expeditiously in public interest and also in the interest of the government servant. Subsistence allowance is paid by the government servant, so that the government servant against whom an order of suspension is passed on account of the conduct and disciplinary proceeding at a criminal case instituted against him, could maintain himself and his dependents until the departmental proceeding and the criminal cases, as the case may be, come to an end, and appropriate orders are passed upon the government servant by the government regarding his right to continue in this service, etc. Etc. Depending on the final outcome of the proceeding instituted against him. The very nomenclature of the allowance makes it clear that the amount paid to such a government servant should be sufficient for their subsistence in this way, in which the price of the necessity of the life are increasing every day on account of the condition of the inflation of people in the country. It is further to be noted that the government servant cannot engage himself in any other activities during the period of suspension. The amount of subsistence allowance.
Yes, once again, sir. I will just pause there. The previous sentence that you read just now, kindly.
It is further to be noted that the government servant cannot engage himself in any other activities during the period of suspension. The amount of subsistence allowance payable to the government servant concerned should therefore be reviewed from time to time, but the proceeding drag on for a long time, and even though there may be no excuse for insisting on such review. When doing so, the authority concerned, no doubt, has to take into consideration whether the government servant is only responsible for the only delay in the disposal of the proceeding initiated against him. If the government servant is not responsible for such delay, or even if he is responsible for such delay to some extent, but it is not primarily responsible for it. It is for the government considered whether the order of the suspension, order of the suspension should be continued, or whether the subsistence allowance should be varied to his advantage or not. Now, Your Lordship may kindly see that order, which has been.
When you are placed under orders of suspension?
Pardon, my lord.
When you were placed under orders of suspension?
I was placed under suspension on 31/12/2020, my lord.
31/12/2020,
my lord. And the proceeding was instituted, my lord, on 1/12/2021, my lord. He was served with his myriad of charges. It is more than almost 1 year.
That case which you are citing, that was a case where 13 years elapsed from the date of suspension. So each case depends upon
My
the
lord.
factual.
Now, Your Lordship, one more judgment, my lord.
Well, I have a small interruption. Can you, Lordship?
My lord, I'm just relying upon.
Yes,
For
my lord,
for your Lordship's kind satisfaction.
Just as 1 minute, I'm just.
Yes.
This order, page 22, annexure 1.
Yes.
It was rejected para 6. Accordingly, the view of the above discussion, the prayer for interim relief is rejected. The original way is pending. Whatever grievance they have, whatever agreed, then put before the original way and pass necessary order.
Why this interim application?
Interim application was rejected in this case by OA.
Yes.
Original matter is still pending.
Still pending.
Is it not?
That has become infectious virtually, my lord. Keeping that matter pending makes no sense.
No, that means your order was only for interim.
No.
Then
I'm asking for this payment of subsistence allowance and the change of the inquiry officer. And now that the interim order has been rejected, keeping that over
as far as this, that is why I told you that many factual aspects are involved, even to extend the amount of subsistence allowance. Reason being, you have not filed a date chart. How can we assess at this stage that the inquiry has been prolonged only from the side of the authority? And you did not take adjournment, you have not cited anything.
Original application reliefs have been
suspension was made in 2000. Charge sheet has been issued in 2021.
Yes. That is not very late.
Original
that is not a consideration. That is not a consideration.
The original application to be taken off expeditiously.
Yes. Yes.
This
yes.
Petitioner has challenged the order dated so and so, passed by the London Central Administrative Tribunal, in rejecting the interim relief. It appears that the original application is still pending, and the prayer made in the original application are as follows. Quote this from paragraph number 1. It further appears that counter affidavit has already been filed, and rejoinder is to be filed. Let the Land Council let the petitioner file the rejoinder within the period prescribed, and thereafter move an application for expeditious hearing of the original application. It is expected that the Land Tribunal shall pass a favorable order and expedite the hearing of the original application number 407 of 2024. Accordingly, the writ petition is disposed of.
Received directed to dispose of the way.
Yes.
Only one request, my lord.
Yes. File your rejoinder also.
After filing my original application till the disposal, inquiry was conducted three procedures.
You must be participating. Yes. Yes. You are to also examine your witness. It's not that. Yes. Next.
My lord, disposal.
Yes, writ petition is disposed of. File your rejoinder.
My lord, only one request, my lord. You will kindly pass that interim order by passing an interim order, asking the disciplinary authority at least to wait. I want to at least to wait till the disposal of the way, my lord. That will not no way create the any impediment for the department, my lord. But this poor man will stay.
You on the one hand, you are saying that the matter is getting delayed. 3 years have been passed, and you are again asking that the inquiry, that proceedings should be stalled. It's
not on that point. I have already said to you, Lord Sumaila, criminal proceedings are pending before the Bhubaneswar, and the man is getting 20
serious counsel. The allegation is 1 crore government money has been misappropriated.
Right, my lord,
So,
that is my lord.
ultimately, that is to be proved or not proved. That's a
My
different.
lord, you have
Yes.
already dictated the order for
Yes.
kindly quote me.
All right, no. It's
Just 2 minutes, can your lordship just give me what
whatever you want to say in that original.
My lord, this is a case, my lord, where he has been made as total scapegoat, my lord.
All right. That we are not here adjudicating that matter on.
That officer, entire officer turnover ଆଜ୍ଞା 15 ଲକ୍ଷ ଟଙ୍କା ବର୍ଷକୁ ଏ ଲୋକ କୋଟିଏ ଟଙ୍କା କୋଉଠୁ ଖାଇବ?
Right. Yes, Nish.
And there was a ତାଙ୍କର ମାଇଗ୍ରେସନ ଅଫ ସଫ୍ଟୱେୟାର ଆଜ୍ଞା ସେ ଅବଜେକ୍ସନ କରୁଛି ତା ଅବଜେକ୍ସନ କେହି ଶୁଣିବାକୁ ନାହାନ୍ତି ସୁପରିଟେଣ୍ଡେଣ୍ଟ has fixed the responsibility just to get out of that his own responsibility again.
Yes, item number 38.
At least he should be allowed to prove himself, my lord.
What is this item 38?
I have no instruction of the petitioner.
Yes,
I have no instruction of the petitioner. In the meantime, more than 12 years passed.
you have?
I have got the petitioner,
Yes.
but I have no instruction from the petitioner in the meantime.
The Land and Council.
What is happening?
This case has been filed for implementation of the order dated one. It is submitted that. What is your good name, Land and Council?
Prafula Kumar Karo. Prafula Kumar Karo.
Mr. Prafula Kumar Karo submits that he has no instructions in the matter. Accordingly, Ms. K stands dismissed. Yes, next.
Item 39.
39. What extension has been sought for? 2012. Non appears
2012.
Non appears dismissed. Next.
Item 30.
It's a dispute of case at modification of the order dated 24/9/2024.
What modification you want?
Okay, area 17 decimal, khata number 74, plot number 79. Instead of area 44 decimal, khata number 7, plot number 62. That belongs to the petitioner's land.
No. What is to be corrected here?
Corrected in para 4, it is mentioned in the order sheet.
Yes.
Area 17 decimal, khata number 74, plot number 79. Instead of area 44 decimal habo, khata number 7 habo, plot number 62 habo. That belongs to the petitioner's land.
They give it in writing.
That is there in that
Application.
Modified. Yes. I know this program. Your option.
Weekly.
33 33.
No, we do order bail matters. Why the
Item 30.
12, my lord. 12 has been passed over in weekly.
We'll list it the next week.
My lordship, in item 38, may I seek my lordship's
All
indulgence?
these matters will come next week.
Oblige.
No,